Hi, JoAnn. Get recording started. Again, my name is Iris Nevins, co-founder and CEO of Umba Daima. We are an NFT studio and network, and we're focused on creating powerful, meaningful experiences in the Web3 space that helps to strengthen and diversify the ecosystem. We do a lot of onboarding, education, and networking events, particularly in Atlanta, Georgia. And we have transitioned our monthly workshop in Atlanta to online so that we can have greater accessibility. So this is our first online one. We're still testing out the format, so bear with us. And any and all feedback is certainly welcome. For today, our guest is JoAnn Holmes. JoAnn is going to be doing a 30-minute presentation on NFTs, IP, and Web3 law. And then after that, we'll have Q&A, and you'll be able to, ask all the questions that you have and get those answers, hopefully. And then we'll close out at the end with some brief announcements and then wrap it up. So to start, I just wanted to do a quick icebreaker, which is, let's see. So if you can share, we'll all go around and just share, if you could have one superpower, what would it be and why? And try and keep it brief, like 30 seconds or less. And I will start. Favorite superpower that I would want to have would be teleportation. I would want to be able to go anywhere in the world at any moment, at any time. And why? Because I love travel, I love people, I love culture, and it costs way too much to travel the world. So if I could reduce that expense or eliminate that expense, that would be amazing. Let's do popcorn style. So I'm gonna pass it to JoAnn.
Thanks, Iris. Can everybody hear me all right? Great. Okay, so the real answer is that I would want to know the lottery numbers in advance, but a more humanitarian answer, I think, would be to be able to be a great negotiator to try to resolve some of the conflicts we have in the world. Oh, popcorn. Okay, so let's see. Nicole, you want to go next?
Thank you, JoAnn Holmes, so much. Thank you very much. My chosen superpower would be to have the power of healing. I've always liked to feel the ability of being able to help someone heal. That's what I've always wanted to do in real life, but that's just not a power that I have. But if I could have it, I want to be able to heal anybody of their physical or mental, emotional ailments, because I just like making people happy and feel good. Thanks. Oh, popcorn. Charles Berry, you go next.
Thank you, I appreciate it. My name is Charles, and by far and away it would be teleportation. To be able to say I could have some Guion in Tokyo today, and then teleport back and be at work, that would be pretty fantastic. And I'm going to throw this to Anthony.
Thank you, Charles. Can everyone hear me okay?
Yeah.
So I am also where I call it Zoom. I wish I could just zoom myself from one place to the other, to the other, to the other, to the other throughout the universe and go check out other planets. That's definitely something that I would have a superpower of. I'm gonna go ahead and throw this to Tevin, Cameron Harris.
Thanks. I think my superpower would be very similar. I would have the power of flight. So I could be able to travel places quickly and to actually see kind of where I'm going as well. because gas prices these days kind of ridiculous. So that is what I would choose, and I will pass it along to Susie Kavanaugh.
Hey, thank you. I always have trouble finding the unmute button. Hi, everybody. I'm Susie. Superpower would probably be dream maker. Just, I know people have dreams. I want people to dream big and would love to support that somehow. So yeah, I am going to popcorn it to, let me see. Did somebody already do Dr. Truelove?
Nope.
All right, Dr. Truelove.
Hey, everybody. If I had a superpower, I would say divine alignment, the ability to be at the right place at the right time. So I guess that kind of encompasses teleportation, things like that. But yeah, I'm going to pass it on over to Praveen Yala Nanchi.
Hey guys, I'm Prav here in Miami. I guess X-ray vision. I guess in the metaverse, I guess seeing through your virtual walls. Thanks. I'll pass it out to did Tevin go?
Yeah, I just went up like 3 people before you did.
Okay. Christian.
Hey, Christian, if you're there, I don't think we can hear you, but you are unmuted.
Sorry. Can you hear me now?
Yes.
Okay, sorry about that. My name's Christian. My superpower would be invincibility because then I could deal with anything. And I will pass it. I don't think Cynthia's gone.
I have not gone, and I apologize for being late. So, hey, everybody, I'm Cynthia Overton, pronoun she, her, hers. If I had superpowers, they would be the ability to identify future tech trends. So I could go make all that money. Okay, I'm not sure who has not gone though, because I did Amanda has not. Amanda, thank you so much for raising your hand.
Thank you, Cynthia, for the handoff. Hi, everyone. My name's Amanda. The superpower I would love to have would be mind reading, because I like to understand people, and I feel like language is such a barrier. So I'd like to believe if I could read minds, that would eliminate some of the frustrations I have day to day. And Quentin, you're up next. Thank you.
Yes. Greetings, Wagwan, coming from Toronto. If I had a superpower, I think I would want to be able to conjure any object I want.
I like that. You have me thinking.
Print some money and thing,
Is there anybody else? I'm assuming the raised hands are folks who haven't gone yet.
I haven't gone, sorry. I'm Daniel Gilstrap from Atlanta, and I would like for the ability for mentally project things. So I'm an artist, I'm an illustrator. I'd love it if my drawings could come to life. Like if I draw an angry face, it would just become a large angry face, and then people would get pretty pissed. Things like that.
Very, very interesting. I'm loving all of these ideas. Y'all have my mind just.
Yeah, I loved how some of y'all phrased the powers, like zooming. That sounded so smart, just to get from point A to point B, but also divine alignment, being at the right place at the right time. That's a genius power, because you would be at the right place at the right time. You would just do the right thing.
All right, who's left and hasn't gone? I see Brent.
Yeah, I'll go ahead and go. Iris, Charles, you guys stole my superpower, so I guess superpower number 2 would be to be a master communicator, because at that point, you know, you can sell anything, you can explain anything to anyone, you can talk to anyone in any room. So that's what I'm working on right now. So hopefully I can turn that into a reality. I'm down in Atlanta, Georgia, by the way.
Awesome. You can popcorn it to somebody else.
What about you, Ashley?
Well, thank you so much, Brent. Hello, everyone. My name is Ashley Schuler, right outside.
Uh-oh, looks like she cut out.
Oh, no. Okay. Am I right here? Am I okay?
Yes, you're here.
Okay, sorry about that. Ashley Schuler, right outside of the DC area. And just in terms of superpower, I would definitely think, the teleportation. And then I'll just give number 2, that TSA pre-check will work for everyone at all times, no matter the circumstance.
Love it. Want to popcorn it?
I would like to popcorn it to, is it Joe Lewis?
Yeah, yes, Joe Lewis here. Everyone, I'm also here in Atlanta, and I've been attending a lot of the Umba Daima events, so I'm glad to be on this one as well. My superpower would be, I think a lot of people said some of the same ones that I would prefer. So if I'm going with a secondary one, it would be the ability to have my ideas. This one is kind of said already too, but have my ideas come to life. So like if I have a movie idea, if I can just spend 1 minute and then it gets actually produced in that minute. And that's it. I pick who is here? Who has their hands up? CH.
Hey, what's going on? How y'all doing? My name Christian. I'm from down south, 85 south of Atlanta. If I had any superpower, it would be to teleport back in time, like to tell all my folks to buy Bitcoin and Ethereum before it was $1. So, we'd be straight right now.
Oh my God, I love all of these. Amazing. I think that is everyone. If there's anyone who wants to go that didn't get to go, feel free to just jump in. If not,
I'll go. Derek, I'm in Atlanta. Superpower would be infinite wisdom and insight.
love it, love it. Anybody else? All right. So I'm going to pass it off to our very, very special guest, JoAnn. JoAnn Holmes is a digital asset and IP lawyer. JoAnn has personally worked with myself and my business, and she's actually had a tremendous impact on us. And so I feel very honored and excited to be able to help her share her wisdom and her insights to the larger community that we're building. And JoAnn's also very good at answering questions in a lot of detail. So don't hesitate to ask any questions that you have. And yeah, let's get it started. Welcome, JoAnn.
Thank you, Iris. So we listened to some nice music, and then we kind of chilled out and talked to each other. So like, I'm ready for a house party and now I gotta gear up to present, but I'm excited to be here with everybody. I wanna make sure that I'm able to share my screen all right. So let me give that a test. Can you guys see my screen?
Not yet.
Oh, sorry. One more button to click. How about now?
Yes, we can see.
Excellent. Okay, so I'm a lawyer. we have the Bar Association to contend with. So a few ground rules so everybody knows what we're working with. The information that I'm going to share this evening is for educational purposes only. It's not legal or financial advice, but I will certainly give you my thoughts around how I consider these issues when I am grappling with them for my clients. This content may be posted online. I believe, in fact, that it will. So please don't share anything confidential. But do feel free to ask questions. I think that Iris is going to be monitoring them. We've got a lot of content to get through because I really designed this with the key issues that I find that my clients and projects have questions around. And I spent a lot of time talking to other lawyers in the Web3 space. And so this is also born out of what I see bright attorneys around the world thinking about and supporting Web3 clients. So let's jump in and have some fun. So who am I? I've practiced law for over 20 years now, and I've been very fortunate to have experience from big law firms to being in-house counsel, and now having my own practice at Holmes at Law, where I help innovative organizations navigate the constantly evolving legal landscape of Web3 so that you can build successful products and services. I have advised clients from startups and entrepreneurs all the way through multi-billion-dollar global organizations and had clients all over the world. I currently manage intellectual property assets in 140 countries around the world. And over the course of my career, I have negotiated with some of the largest organizations that their core asset is intellectual property, like Disney and the NFL and Microsoft. And so I've either negotiated with them or represented them, which helps me have perspective from both sides as I'm thinking about how I work with and support the success of my clients. So kickoff question, just to get a sense, and Iris can share with me a little bit later around what is your creative superpower? Why are you here joining us? Are you a designer? Are you in community management or marketing or something outside of the Web3 space? And you're here because you just want to learn around the basics of Web3. And are you more on the independent contractor and freelance side of things? Are you with a DAO? That would be great. We're going to talk about DAOs this evening. Or are you with a larger, more traditional company? So help us get a sense of who we're talking to, and that will be helpful because I can think about the way that I answer your questions and tailor that to our audience. So we're going to start out with some basics, some fundamentals of intellectual property, because all of Web3 is IP. You have baseline, you have trademarks, and trademarks are brand names, slogans, and logos. Sometimes a brand name will line up with a domain name. So the examples that we have here are for Apple. The brand name is going to be Apple, iPhone, iPad. The slogan is going to be something like Think Different, and the logo is going to be that apple with a bite taken out of it. The domain name alignment would be apple.com, where we at least used to, for me, be up in the middle of the night trying to furiously press refresh so we can order our products. So that's the domain name, apple.com. Trade dress is the look and feel of something. And so we can look at the visual that's on your screen, and even without seeing the brand name iPhone, we know from the look and feel, that's the actual legal term, that that collection is an iPhone. And so that trade dress or look and feel is a type of intellectual property. And then there are trade names. These are not intellectual property, but they are typically company names or doing business as DBAs. They're the way that we identify the company or organization associated with products. So if we look at the NFT world, then NFTs also have trademarks. So we have an example here of Bored Ape Yacht Club. That is going to be a brand name. Bored Ape Yacht Club is the brand name for a collection. The logo that you see there is going to be, again, another type of trademark. And a logo, just so that folks are aware, can be both a trademark and it can be protected under copyright. And we're going to talk about copyright a little bit later. One thing to keep in mind is that here in the United States and abroad, outside the US, the law is a little bit more forgiving in some ways, but here in the US in particular, you get trademark rights by offering and selling a product and service under a trademark, right? So you can kind of reserve your space in line if you have a brand name, for example, that you're intending to use, but you haven't started yet. But in most instances, you're not going to be able to get a registration and a recognition of your ownership of that trademark until you're actually selling. That's important because sometimes people in NFTs talk about how all of the commercialization rights or all the IP should be granted to buyers. That's not legally possible in terms of trademarks, because trademarks only go to the products or services that a trademark identifies. That's why we can have Delta Airlines and Delta faucets. You're not going to go to the airport expecting to be able to buy appliances for your bathroom. Also, the registration, when you go to the US Trademark Office and you want to get the government to recognize your ownership, they're only going to give you a registration that covers, again, the things that you are already using that brand name to identify or that you intend to. With NFT collection, sometimes the question is, well, where should I try to get a registration? Because there's no way you can file one trademark application in one place and get global trademark rights. And so it's really a question of thinking through where your likely buyer is going to be and where your potential infringer is going to be, and making a decision around the investment of getting a trademark registration. So a few things also to think about under trademark law. When you own a trademark, you have an affirmative responsibility to police, to go out and check the internet, for example, and know, is someone infringing your trademark rights? And if so, take action against them to force them to stop. That might look like a cease and desist letter. It might look like litigation. You also need to have some quality control standards. So let's say you license your trademark to someone else and say you can use it. Well, they can't just use it with abandon in whatever way they want, because the underlying purpose of trademark is really to protect consumers. So let's say that your college licenses the right to use their college logo to Nike. That license is going to have some quality control standards to say you can't put our college's logo on Nike gear that's going to fall apart as soon as someone buys it. Again, there's got to be some quality control there. If you do issue an open license with no quality control standards and so forth, then you can lose your brand, and that can have a lot of value. So you want to be careful about doing the things that protect your investment in owning that brand, because that's how people know the quality of your products and services. Another thing is to think about famous marks. And so like we have a brand like McDonald's, for example, and McDonald's, because it is so famous, their core product is going to be selling fast food. However, McDonald's is going to have an extra scope of rights called dilution rights for famous marks, because so many people know what McDonald's is. So when you have a very famous brand, you get some additional trademark protections. The illustration that you see on your screen is a reflection that under effectively our First Amendment rights as Americans, people are allowed to make certain social commentaries. And sometimes that might mean using someone's trademark or brand in making that social commentary. And so we're trying to balance the commercial rights of the brand owner with the First Amendment free speech rights. And that can come into play when you are a creator. So another type of intellectual property to think about is the right of publicity. And when we think about that, we're effectively thinking about name, image, likeness, voice, anything that uniquely identifies, most often a celebrity, an athlete, an influencer, because the commercialization of their name, image, and likeness is going to have monetary value. So when we're thinking about this here in the States, there's no federal law that is going to uniformly govern how that right of publicity will be managed under the law. There's really going to be state law, and there's going to be litigation from cases that are filed that set precedent. When you're thinking about where your risks are for potentially using someone's right of publicity or their image, maybe in a photograph to make an NFT, for example, there's really going to be a question around where is that person domiciled. So if they are in California, then a lawsuit is most likely going to be governed by California law. Elvis Presley being famous and being from Tennessee, there is right of publicity law in Tennessee. So when you are thinking through the question of, am I going to take the risk of using a celebrity's image without their permission, then one of the things you would want to think about is, what is the right of publicity law in the state where they reside? A key question around that is going to be, is it commercial use? Or again, is there some sort of First Amendment protection that you're making a social commentary or a parody or something to that effect that might allow you to have some use of a celebrity's image without infringing their right of publicity? That's really a nuanced legal question and something that it is very wise to speak to an attorney about. So another area of intellectual property law that's very important to Web3 and NFTs is copyright. And so I kind of, for organization purposes, break them down into creative copyrights versus business copyrights. Creative are going to be all the kinds of things that usually entertain us. So that might be art, movies, film, books, sculpture, choreography. Whereas you can have copyrights in your business as well. And that might look like software or training materials or video that you record or educational courses, even your website, which is a digital brochure effectively. All of those things are protectable under copyright, but I sort of put them in the category of business copyrights. If we're thinking from the Web3 and NFT context, of course, we have digital art, we have in-game assets, we have illustrations in the metaverse. All of those things are reflected and protected under copyright. Key thing to know is that copyrights do not protect ideas. If you want to share an idea about something, then you probably want to move to contract law and look at a non-disclosure agreement or confidentiality agreement. But pragmatically, I always advise my clients, don't tell people things that you don't want them to know, because a non-disclosure agreement or confidentiality agreement is just a piece of paper until it's enforced, and enforcement can be expensive. So a copyright is the kind of legal protection that you get in an original work. If you take someone else's work, you can't get a copyright in it. Copyright is a way, going back to the foundation of the Constitution, that we have sought as a country here in the United States to protect creativity under our law. You get a copyright once something is fixed. So if you sit down at the piano and you play a beautiful piece of music, but it is not recorded and just the people in your earshot enjoyed it, you don't have a copyright in it. But if you did that same thing, took out your smartphone and recorded it, as soon as it's recorded, you immediately have the copyright. So once something is a fixed form, like you wrote it down, or a digital form where you recorded it and saved it, then you as the author in that copyright immediately own the work, unless it's a work for hire. So what rights do you get as a copyright owner? You have the right to copy, make derivative works, to display it, to perform it if it's a performable work. This is called the bundle of copyrights. And if you create a work with collaborators and several different people, several different authors bring together their pieces, then you have a collaborative work, and then each one of those creators can own a component of that copyright. So to use an example of what a derivative work is, because that's pretty important as we're thinking about the benefits of being a copyright owner, you have the idea. Remember, we said ideas are not protectable under copyright, but you can try to protect them under a non-disclosure agreement or confidentiality agreement. So if we use a Harry Potter book that J.K. Rowling authored, then that is an original work. She owns the copyright in that work. And then she also had the right to create derivatives. And so she licensed the rights to use her books and have them made into films. And then those films are derivative works. And importantly, those films are another stream of revenue for that creator. One of the important things to think about with copyright is registration. So if you go to copyright.gov, there's great information there, including information for beginners. I typically encourage people to file copyright registrations for themselves unless there's something unique going on where they need an attorney. And that's different from trademarks, which can be a lot more nuanced. And the reason why I encourage people to file for themselves with the Copyright Office is you can get a copyright registration for under $100. There is a review process at the Copyright Office, but it's a lot easier to get that registration than it is, let's say, for example, to get a copyright or a patent registration. And once you have that registration, you have the right to sue for infringements. You can have your attorney's fees paid if you prevail in that lawsuit, and you have the benefit of statutory damages and not having to go through the process of producing evidence of what your losses were or someone else's gains are. So just to keep things very simple, for non-willful infringements, those statutory damages can be as little as $750 per work and as much as $30,000. If someone purposefully and blatantly knocked off your copyrighted work that has been registered with the US Copyright Office, you can get up to $150,000 per infringement, or excuse me, for infringements per work. So we've got a lot to cover, but if you have questions about this, I would ask you to take a quick moment, put them in the chat so we've got a record of that, and we can come back and address all the questions at the end because we've got quite a bit more content to go through. So let's sort of set the stage for Web3 with a mindfulness that folks who are attending may be coming at the conversation from different stages of experience with Web3 and digital assets. So to borrow from Chris Dixon at A16Z, we've got sort of three phases of the internet. The first phase of the internet was read, where we effectively had digital magazines. Websites, for example, were a way that you could go read the newspaper rather than physically holding it in your hand. Not very interactive. Web 2 brought that interactivity. We went from read to read write. And so that looked like a lot of what helped that was the mobile internet and being able to communicate through devices that we have on our phone for many people and for much of the world. That was more cost effective and affordable than traditional computers and a desktop or a laptop. And then we also had centralized organizations that earned quite a lot of money through creating marketplaces and managing our data and giving us centralized places to communicate. So that looks like Facebook, that looks like Amazon as a marketplace, that looks like Google as a data aggregator. The issue with that Web 2 model of centralized power was that shareholders of those companies might have earned quite a bit of money, but the contributors and creators did not. Web 3 is the next turn where we go to read, write, own. And so the ethos of Web 3 is really around contributors in the marketplace, in the global marketplace of Web 3, being able to earn some of that value, participating as community and getting value out of that. And so the stage that we're at now is very much with that ethos around how does everybody who participates and contributes have an opportunity to be able to earn something from that contribution. When we say Web 3, what do we mean? I think of that as 5 tent poles. So the baseline is cryptocurrency, right? That is our monetary unit. There are over 10,000 cryptocurrencies. There's debate around what the value of those cryptocurrencies are, but they are functionally our monetary unit that allow us to have transactions on the blockchain. Number 2 in our 5 tent poles is decentralized finance. And so what that looks like is a digital version of our traditional legacy financial system. So we have opportunities to earn yields on stablecoins. We have opportunities to use assets for collateralization. We have effectively a corollary, and depending on where you are in the world, you might even have opportunities to have corollaries to stocks in a traditional stock market through security tokens. Here in the United States, we have some restrictions around that, and we will talk about some of the regulatory issues later on. But again, decentralized finance is a corollary to the traditional financial world. Then we move into what's more of my wheelhouse, which are NFTs, or non-fungible tokens, and we're going to break down a little bit more of what that is. But effectively, an NFT is 2 things. It is a token or a digital certificate of ownership on a blockchain, and a blockchain is just open source software. And then the second part of an NFT is whatever that token represents. It can read to a digital asset like digital art, and it can read to a physical asset like a house or a car. And we already are living in a world where houses are being bought and sold through the distribution of an NFT. The 4th tent pole in Web3 is decentralized autonomous organizations, which are the ways that people are coming together collaboratively, across the world for different functions, to offer products and services, to invest, to support charitable goals, and we will talk a little more about DAOs later. And then the 5th and final tent pole is the metaverse, which is our digital community. And so we have sort of Web 2 metaverse that looks like Minecraft or Roblox. And then we have Web 3 metaverse that's built on the blockchain that looks like Decentraland and Sandbox. And these organizations and ways that we build digital community are constantly evolving. So those are our 5 tent poles of Web 3. As I said before, the 2 components of an NFT are, again, that token on the blockchain, which is a digital certificate of ownership, and the digital or physical asset that token references. So what do we use NFTs for? So you may be familiar with PFP or profile pics, certainly digital art. gaming assets. If you maybe have played Web 2 games, you might have purchased skins or weapons or other things that you really effectively had to use in game. And when you left that game, any investment that you had made in those assets were pretty much gone, because trying to sell them to someone else is most likely to be a violation of the terms of service of the game. Whereas with NFTs, those are gaming assets that become your property that you then can use, hopefully interoperably across different worlds in the metaverse, or that you can buy and sell like other assets that you may own. There are collectibles, there are sports memorabilia like NBA Top Shop, there are already music NFTs, domain names like .eth domain names. And then NFTs can be sort of authentication tools, so tickets, membership authentication, subscriptions to a set of benefits. And I'm sure that there will be other uses for NFTs that creative and innovative people will evaluate going forward. So what are the benefits of NFTs? First of all, we have provenance. You can see how something traveled across the blockchain from one owner to the next based on the smart contract that shows that ownership history. Also, authenticity. Again, the transparency of being able to see this is a real asset that I bought from Beeple, for example, or Umba Daima. You can see that travel from the creator's digital wallet to a subsequent buyer, because all of that ownership history is reflected in the smart contract of the NFT and in the blockchain. Scarcity. So, one of the problems with Web 2 was this concept of right-click save. If your digital art, for example, was on the internet, it was not scarce. Anybody who understood how to grab and save a digital copy was able to have access to it. But if you want to have a limited number of originals, again, the blockchain will be able to authenticate that there are only a certain number. With many PFP projects, there are a collection of 10,000. And so you can confirm using the blockchain that there were only 10,000. And if a particular asset does not have a representation and a history on the blockchain coming from that creator's original digital wallet, then you know it's not a scarce asset. It is a right-click save. And then, of course, royalties for creators. So one of the challenges for creators historically has been, once they sold that piece of art, for example, all the revenue that they were likely to make from that was immediately over. Whereas through coding of smart contracts, you can have for that original creator the opportunity to have ongoing royalty and revenue stream. So again, if you have any questions about what we just discussed in terms of what is Web3, what is an NFT, what are the benefits to NFTs, please drop those in the chat, and we're going to address as many of those as possible when we finish up the core presentation. So let's jump into IP commercialization, because for a lot of NFT creators, there are real questions both on the creator side and on the buyer side around what rights does the creator have, what rights should the creator consider keeping, and what rights does a buyer or a collector have. And that really comes from three different areas of law. One is a trademark, one is copyright, and the third is contract. And we call those things, when they come together, IP, or intellectual property commercialization. So the first piece is trademark. And again, remember we said that trademark is an umbrella term for brand names, slogans, and logos. You really want to think as an NFT creator road mapping a collection, is it wise for you to grant commercialization rights around the brand name and the trademark? Most often the answer is no. And the reason why the answer is no is because, again, in order for you to keep rights in your trademark, you need to be able to exercise some quality control. You can only grant those rights in connection with products and services that have actually been sold under your brand. And so it's very difficult to grant a mass license. Also, once you grant those licenses for buyers to be able to use your intellectual property, you're effectively giving up control around how your IP assets are going to be used. Now, some people have decided that that is worthwhile, but with trademark in particular, if you grant broad licenses and you are not policing and you are not maintaining quality and you are not limiting those licenses to only the products or services that you have brand rights for, then effectively you're giving up your legal rights in that trademark. So trademark is not an area where I suggest to my clients that they try to grant broad commercialization licenses. That's not to say that you can't grant licenses, for example, in a partnership where you can have more control. I'm hearing some feedback, so I don't know if there's maybe somebody off mute there. So let's move on from trademarks to copyright. Under copyright, let's talk about creator rights first. So under US copyright law, and we did speak about this a little bit before, but to revisit it, if you're the author in a work and you're not under a work for hire agreement, as soon as you record in a physical or digital format, you own the copyright in that work, and you get that bundle of rights that we talked about, the right to create derivative works, the right to copy and display and so forth. And so that is the default under our statute and our law here in the United States, and for the most part throughout the world, is that the creator is going to effectively retain all of the rights in a copyright even after someone purchases an NFT. Think about it from a traditional art perspective. If you sell, a famous artist were to sell a print, that does not mean that the buyer has the right to be able to take that print and make movies from it or put it on t-shirts or other gear, right? All they have is the right to be able to own that physical piece of art, display it in their home, maybe display it in a gallery. That's corollary to digital art and NFTs. So what rights does a buyer get when they buy an NFT? Without a commercialization license, in effect, that is a contract telling a buyer that you're going to get extra rights. But without a commercialization license, you fall back to statutory law and case law. What does that mean in real world? Remember, we said an NFT is two things. It's the token or deed of ownership, and it's the asset that that token relates to. So when you're a buyer and you buy an NFT, what rights do you get in the token? You get the right to sell it to someone else and transfer that deed of ownership to someone else. And then that will be recorded in the smart contract when you make that transfer. But what about the asset that the token relates to? You get, just like when we were talking about physical art, you get the right to be able to display that digital art, let's say, for example, if that's the asset that's aligned to the deed of ownership or token, you get the right to display that digital art in your home, maybe on your phone. And you might, again, get a right to display it in a gallery, but you do not automatically, by buying an asset, get a right to go shop it to create a film or a cartoon or make new artwork that derives from it. You don't get any of those rights. If you do get those rights, it's because there's a commercialization contract from the IP owner or creator giving you additional rights. And that's really important because a lot of people don't understand what they're getting when they buy an NFT. Effectively, you're buying the right to the token and the right to sell it forward, and you're getting a right to a private display of the digital asset. So if you do have a commercialization license, what extra rights are you getting as a buyer? Well, that depends. And that's where we get into the contracts that frankly, not very many people read in terms of service or on, most likely on a Web 2 style website. Somewhere there are going to be commercialization terms that explain to you, buyer, when you bought this NFT, you got this set of commercialization rights. And there's a spectrum. So the most locked up on the spectrum is going to be the Disney model with all rights reserved. You may not even have the right to make fan art, like literally all of the rights, all of the bundle of copyrights, everything is centrally managed. And as a buyer, you get that limited license to be able to display in your home for private use. Then in 2017, 2018, Dapper Labs evolved all of intellectual property licensing law with CryptoKitties, where they said, we're going to give you a broader scope of rights to our IP if you're a CryptoKitty buyer. And what you're going to get is the right to commercialize up to a financial cap, up to $100,000. And there were also some limitations around not co-branding and not doing obscene or hateful things with the CryptoKitties. But for the first time ever, by buying a digital asset, you got the right to go commercialize that CryptoKitty that you bought. Then recently, through Yuga Labs, the Bored Ape Yacht Club collection expanded the commercialization model even further. And so what Bored Apes stands for in the Web3 community is broad commercialization rights. So there's not a commercialization cap, but keep in mind, it is a license. And unless a license says, as a legal term called irrevocable, irrevocable means I can't take it back, right? So if there is not the term irrevocable in that license, then Yuga Labs could sell their IP rights, let's say, for example, to Disney. And there's a real question for all those Bored Ape Yacht Club owners who went out and commercialized their apes. What happens if Yuga Labs sells the IP rights to someone else, and then that new company says, well, actually, we're not going to allow you to commercialize anymore? Another thing to think about is if you sell your ape to someone else and you've built a business around it, you've lost your IP rights. You can't really use that ape in connection with your business that you've built anymore, unless you get into complex questions around, does the new owner give you a license back? Do the terms from Yuga Labs allow you to do sub-licenses? There are a lot of legal questions that come into play with these broader commercialization rights. And then the broadest and most generous spectrum from a copyright commercialization rights perspective is something like the nouns or MFers projects, for example, where it's Creative Commons Zero, where the copyright, the author of the copyright, the creator has said, I'm releasing to the full extent of the law, I'm releasing my copyright. But then that means when you buy a noun or an MFer or one of those projects that's acting under Creative Commons Zero, the creator didn't have a copyright right to give to you. So then you don't own the copyright in that work either. It gets really messy, again, if you're trying to think about how can you commercialize or build a business around that asset. So keep in mind with Creative Commons Zero, because a lot of people are big fans of this, there are certain things you cannot opt out of. So for example, it does not give trademark rights, right? Creative Commons Zero is a copyright law issue. It's not jurisdiction specific. So in some parts of the world, there are these things called moral rights, where certain things can't be done to demoralize a work of an artistic work. And so you cannot release rights that the law won't allow you to release. So there are still limitations even under Creative Commons Zero. That's why the copyright is released to the fullest extent of law, understanding the law won't allow us to release all copyright. It's kind of akin, to open source software. So if you're thinking of a parallel to Creative Commons Zero, that might be one. Things to consider as a creator as you're coming up with what should your commercialization license look like. Again, what scope of authorized usage? Are you going to be like CryptoKitties with a dollar cap? Are you going to be like Yuga Labs with the Bored Apes where there's broad commercialization? Again, you cannot have unlimited trademark usage rights because trademark law would not allow that. Some commercializations rights say you can't, even if we allow you to use our trademark to some extent, let's say there are parameters that the law would recognize around that trademark license, then you can't go co-brand with someone else, right? You can't do a partnership because the creator wants to keep those co-branding rights because there's a lot of revenue that can come from that. Royalties and secondary sales are something that you want to think about. Like, do you want to make sure that you're on a platform, for example, where the smart contract can maintain that secondary sales royalty? Do you want to have limitations so that people are not using your, let's say, digital art for obscene or offensive or pornographic purposes? You want to, because litigation is already happening in this space, you want to think about, where do you want to fight? Do you want to be fighting in Kazakhstan and Egypt and South America and everywhere else? Or do you want to say, like a traditional contract would, if we have a dispute, it's going to happen on my home turf here in the United States? And then you also want to think about the marketplaces and OpenSea, Foundation, Nifty Gateway. All of these are going to have their own set of terms of services and standards. And you want to think about that as you're thinking about your commercialization licenses as a creator. We talked a little bit about royalties, but again, keep in mind, royalties, we're still early in this innovation, they're not foolproof. Royalties are going to be reflected in smart contracts, but they can fall off depending on the protocol, depending on the marketplace. Some marketplaces are going to automatically allow for splits and distribution to wallets of different creators. Others are not going to have that capability. And royalties can be lost off market. There are other reasons that royalties are lost off market. You might be gifting something to a family member and you don't want to have to pay royalties for that gift. It's not a commercial use. Or you might be moving an NFT from one of your own digital wallets to another, and you don't want to have to pay a royalty because you're moving your asset from one place to hold it to another. And then another thing to think about is traditional contracts, particularly if you have collaborators. There might be off-chain contracts that need to go into more details around royalties. In terms of creative collaborations, let's talk about that a little bit more. You want to think about rights clearance. So if you've got an NFT, there could be art, there could be music, there could be several contributors, there could be rights of publicity, again, as we spoke about before. You want to think about if one central person or organization is going to be managing the NFT, do you want them to just manage it and then send out the revenue from the NFT sales to all the contributors? Or do you want to transfer ownership, right? When you own something, you also become a target if there's a dispute. So thinking through who should own what in terms of collaborations. If you're going to be issuing licenses to someone to be able to use your work in a collaboration, you want to think about for how long, how can they use it, in what territories and what types of media, in which metaverses, for example. And then again, royalties and revenue sharing. Is it all going to be managed on chain so that the distribution to digital wallets happens automatically? Or are you going to be off chain, in which case you want to have an audit right to check and make sure the books are right and that everybody who collaborated on an NFT is being paid fairly for their contribution. So if we overview the types of NFT contracts that we just talked about, again, we have IP commercialization licenses that are going to have trademark potential licenses, but I would ask you to be very cautious about trademark licenses. And then you're going to have copyright side of things, from the Disney lockup model all the way out to Creative Commons Zero. You're going to have publicity rights licenses potentially, especially if celebrities are involved. You're going to have collaboration agreements for those who are contributing to a combined NFT. And then again, you're going to have marketplace terms for OpenSea, Foundation, and other marketplaces. So again, if you have questions, please jump into the chat and share those so that we can see where the questions are arising. I know we're moving through things quickly so we can present all the content, but we're going to circle back to the questions at the end. So now let's get into regulation, because this is a big question that a lot of the NFT community has questions around. And a core important piece of the regulation is around securities. I am not a securities attorney. I am an intellectual property licensing and monetization attorney. But because I am a lawyer in Web3, I do have visibility to a lot of the legal issues that impact innovative organizations that are trying to manage all of the legal pieces to be able to, again, sell successful products and services. So a key question is around particularly tokens, and tokens can be fungible or non-fungible. So an ERC20, like ETH, is going to be a fungible token, and an NFT for a rare or scarce asset is going to be a non-fungible token. But depending on things like how you market that and present that to a community, it might look like a security, or what the Securities and Exchange Commission here in the United States calls an investment contract. And how are they doing that analysis to see whether you're creating an investment contract that has to have regulatory compliance? You might have heard of that test. It's called the Howey test. It literally dates back to the 1930s. So there's a lot of discussion around how that test might be outdated, and we need more current law for digital assets in Web3. But effectively, what the Howey test looks at is there an investment of money in a common enterprise, primarily with the expectation of profits based on the managerial efforts of others? So what does that mean in plain English? That means you're coming together with others, pooling your money with the expectation that you're going to make a profit from it. And you're looking for others, because of their history of success or the promises that they're making, for whatever you're buying to go up in value, right? Win Lambo. So there are some watch outs with securities, and I cannot tell you that there is an absolute safe harbor from securities regulation and needing to comply with those laws. But one of the ways that you can try to address that is focusing on utility tokens. And some of the ways you can do that are having tokens that focus on governance. So maybe members are voting on the way that a token is going to be used. Maybe you have a token that offers a social benefit or membership or access to some set of benefits. So that might look like Friends with Benefits, for example, where it's a social group that by virtue of holding a token or holding an NFT, you get access to that community. Or it might be for a product or service purchase. Think old school Chuck E. Cheese, right? You go to Chuck E. Cheese and you don't use dollars or coins to be able to let your kids ride or play games at Chuck E. Cheese. Those tokens have a function to be able to purchase a turn on the games. But you still have to be mindful when you have those tokens, including NFTs. Again, NFTs are non-fungible tokens, right? And so you want to watch out for things like information sharing. If you're issuing a roadmap as a creator, there's something of an argument, as I have heard securities attorneys say, for example, about Yuga Labs with the Bored Ape Yacht Club. They are issuing a roadmap to help their buyers understand how being an ape owner is going to have value for them, that the owners of those apes are going to be able to commercialize. That roadmap could very well be deemed a security, right? It can make the project look like a security that needs to be in compliance with regulations from the SEC. So then there's a question around, well, okay, if you're going to issue that roadmap, are you disclosing it publicly to everybody in Discords, on Twitter, on Telegram, on a website? Are you getting that information out as publicly as possible so that people have that information and can make informed decisions? Or do you offer no guidance at all, right? So for example, for people who own .eth domain names, which again are NFTs, there was no discussion in advance at all that there was going to be a token drop. Everybody just got it by virtue of being a .eth domain name owner. And so there's a real question around in the legal community around whether giving lots of information versus giving no information is better for trying to stay out of trouble with the SEC. But what the SEC ultimately wants is for some people to not have more information than other people because that looks unfair. You also want to think about your marketing claims. You do not want to be making any sorts of suggestions around, you better buy this collection quick because the floor price is going to go up, right? Again, that starts to look like a representation of a security. You also don't want to make references, well, the last time that we as a creative group dropped a collection, like the floor price went to the moon immediately. Because even if you're not talking about this specific collection, you're making a representation that would lead a buyer to think, well, if their last collection went to the moon, then this one is likely to as well. And then even if you don't make any kinds of representations around the value of your NFT or token, people who hold that token can create a liquidity pool, go to a DEX or a decentralized exchange, and then start trading it, and then it has a financial value, and that could start to make it look like a security or a share, akin to a share of a company. So it's difficult under the current law and regulation to find a truly safe way to be absolutely confident that you're not going to run afoul of the law in the United States when it comes to the SEC. Another thing that the SEC has signaled and told us that fractionalization and similarly pooling could look like you are creating a security. There are marketplaces that do this, but be very, very careful, because when you're doing that kind of thing, when you're taking, let's say, again, something like a CryptoPunk or an ape or a Boss Babe or a World of Women that's going to have a higher floor price, and fractionalizing that out so that different people can own a little piece of it, that starts to look like the way that shares of a company are fractionalized out so that people can buy a little piece of a company. That again starts to look like something that the SEC has already told us they are going to be scrutinizing. So if we overview the legal challenges of NFTs, you've got Web3 is global. There's no one law that governs everywhere, but the people participating in Web3 are everywhere. You've got anonymous dev teams and wallets. And so if something is not right, it can be hard to identify who did the wrong, because people can be anonymous, they can be pseudo-anonymous. It can be really quite difficult to tell who you're dealing with on the other side of a transaction. There are private sales off marketplaces. So while marketplaces will try to, oftentimes, especially centralized marketplaces, will try to comply with the law of where the owners or the leadership are seated, in a decentralized marketplace or a private sale, that can be very difficult. The blockchain is immutable. Once something has happened, it can be very different to reverse whatever occurred. There is fraud, there are rug pulls, there are NFTs that are represented as one of ones on one marketplace and they get sold again as a one of one on another marketplace. As we spoke to, there's lots of regulatory uncertainty, and there are lawyers whose whole profession is to look for gray areas in the law and go file lawsuits. And so one side of uncertainty around the law is from regulation, and the other side is from lawyers who are looking to sue where there's not clarity in the law. And in the United States, effectively, anybody can sue anybody for anything. So if we do a legal overview of what we've discussed, we've got a few different areas of law. We've got IP, which includes trademarks and copyrights, and things like, first sale of a copyright versus recurring royalties. We've got contract around collaborations, commercialization licenses, terms of services for a marketplace. We've got corporate, we're going to talk a little bit later about DAOs in managing creator liability. Securities, again, in the next section around DAOs, we're going to talk about fundraising. We already talked about fractionalization. There are issues where sometimes we know that this happened with OpenSea, for example. Someone might front run and try to be able to use insider trading to get an advantage on a sale before it's broadly available to the public. You've got financial issues around tax and gambling law, potentially, depending on whether there are loot boxes and other things like that in gaming. And then regulations, again, you've got, and we'll talk about this in DAOs, but you've got questions around, again, securities is regulation, but you've also got privacy laws. You've got anti-money laundering and know your customer and privacy. Privacy in the United States is regulated on a state level. And then globally, you've got things like the European long arm statute that impacts European citizens no matter where they're seated in the world. So there are a web of different privacy laws for compliance purposes as well. Okay, once again, if you have questions from this last section, please drop them in the chat so that we can try to come back to them. And we're going to move on to our last section, which is around DAOs. So DAOs are decentralized autonomous organizations. And what are DAOs? They are effectively aligned communities supporting a given purpose that have a treasury or a digital checkbook. And they do things like communicate and vote around the direction of what they want the DAO to achieve. There are different types of DAOs, and there's some controversy in the Web3 space around this. Old school DAOs, so effectively from last year, were really more driven by decentralization and being autonomous. And so they were very driven by smart contracts with the concept code is law. Code is not, in fact, law. Code is code. Law still governs every aspect of our financial and business and personal lives. And so code can be directive and can be helpful in reflecting the intent of what people came together wanting to achieve, but code is not law. We can't dismiss the law, and we're going to talk about some of the ways that laws impact DAOs. So the early version of DAOs were, again, smart contract governed. DAOs have evolved to allow for more member governance. And within those members, because there can be thousands of people participating in DAOs, there's now a concept of pods or guilds, which would be kind of akin to departments in legacy companies, so that people with specialized expertise or interest around a given aspect of a DAO can focus on driving that segment of the DAO without everybody having to vote on everything where there may not be interest. So what are people using DAOs for? A myriad of different things. DAOs can be used to issue grants, say to creators or to devs. They can be for impact around public goods or charities. There can be investment. Seed Club, for example, is facilitates investments. They can be for offering products or services, and they can be protocols. If you think of MakerDAO or Uniswap as a decentralized exchange, those have, especially with Uniswap, there is a centralized company, and then there's the decentralized component that's a DAO. And that's a model that I think a lot of companies and organizations will be considering. How do we have our legacy company, and how do we bring community in with a DAO component? That's one of the things that I talk to clients about trying to figure out, because there are good reasons, and we'll talk about some of them, to have traditional company protections while also inviting membership and community through DAOs. So what are the benefits of DAOs? Some believe that they are more efficient relative to traditional companies. There's an opportunity for shared ownership, but again, we get into some of the questions around tokens and securities and regulation issues there. There's an opportunity, as we just spoke to, around member governance. It can be trustless if it's smart contract driven. If you don't trust people or members to make good decisions, then you can say the smart contract will reflect how we're going to behave. And if the regulations are challenging for what you're trying to achieve, when you truly get to the objective of decentralization, then it's hard for any one given government to say that we get to manage you. So if we think of Ethereum, for example, or Bitcoin, it is truly decentralized. And so for one government to be able to say, I'm going to have autonomy over you, when there's no central person or company that has authority over those protocols, then effectively you can get to the point where you're moving away from some regulation that a DAO might think is too onerous, for example. The problem is sort of a chicken and egg question around, you can't get to decentralization without having a core group of people who are driving the mission of the DAO. And it's kind of hard to get to that decentralization when you're trying to also comply with the regulations of where those members are. So NFTs and DAOs have a natural synergy. Sometimes NFT communities can form a DAO, and why would they do that? The NFT might be serving as an authentication tool for a community. So if you have an NFT, then we know that you are part of our community with a common goal or objective. And NFT might be used to raise money for the treasury of a DAO. So again, you might buy, for example, an NFT because you want to get behind a charity and you want to be able to have a way to raise funds for that charity. NFTs and DAOs might come together because a creator wants to give their community an opportunity to vote on what that creator is going to do. And so that synergy between the creator and the DAO might create a collaboration between them. Marketing. So if you have a DAO, your DAO members might market your collection for you and cause others to want to come and see the value in your art, for example. And there might also be brand partnership potential. So if you have a DAO that is developing products and services, legacy brands might see a value in what you're doing and want to come along and partner, and then there are revenue opportunities there. Let's talk about some of the legal issues, and these are critically important with DAOs. First and foremost, when I am advising my clients, my objective is to protect them, to protect their personal assets and their families. And so if you do not have, let's say here in the United States, a company like an LLC or a corporation where you have some kind of recognized legal protection that separates you as a contributor to the DAO from yourself as a person, then you default to a general partnership. And what that means is all the members of the DAOs potentially have all the assets of the DAO in the treasury and have all of the risks of the DAO. And I said to you before, in the United States, effectively, anybody can sue anybody for anything. So another member of the DAO might have done something that violates law and you didn't even know about it, but because you were a DAO member, in particular, if let's say you have multi-sig authority over the treasury assets, or you were a recognized leader in the DAO, you become a target for a lawsuit potentially, or a target of a regulator potentially for something you didn't do and you didn't have control over because another member of the DAO did that thing. And so it is very important even if it feels like a violation of the ethos of a DAO, to protect yourself and your personal assets, especially if you are doxxed and people can identify you as a DAO member, it is really important to think about protecting yourself, protecting your home, your bank account, and your family's assets by getting some kind of company wrapper to separate the DAO from you as a person and your personal assets. And once you do that, you want to do things like, and I know again, this might be offensive to those thinking about especially legacy DAO concepts, but you want to have a separate fiat bank account. You want to have a digital wallet that is only for the DAO, that is not yours personally. You don't want to put your personal funds together with the funds of the DAO. If you get to the point where you are protecting assets or entering contracts, those need to be entered in the name of the company for the DAO and not you as an individual. All of those things, again, help protect you and your personal assets. Also, when you're thinking about fundraising, you want to think about what jurisdiction are you in and what are the laws that govern fundraising for a DAO where you are. Here in the United States, we have something called an accredited investor. And the concept is if you have over $1 million in assets, or you as an individual meet a certain threshold, which I believe is $200,000 or more in annual income, then our regulators deem you to be a more sophisticated investor. And so you might be able to invest in things that someone who doesn't meet those thresholds cannot invest in. Or you might want to have someone who is qualified in the law of this space go in detail in helping you understand how you can comply with crowdfunding regulations to be able to raise money from more retail level investors. But there are definitely laws around collecting money to be used around building out a company or products or services. And if you're in violation of those laws, there are very real risks that you're creating for yourself. Of course, then there are also taxes. And with DAOs, especially if you have members outside the United States, you could have tax issues at the international, federal, state, and depending on where you are, even local levels. And those taxes could come from profits on product and service sales. There are also going to be taxes that are due based on if you as a DAO are an employer or you are working for the DAO as an employee. The way that governments build money to be able to do things for community is through taxation. And governments are not going to quietly forgive DAOs if those DAOs or the members owe taxes for what they're doing. Also, if you want to have transactions off chain, right? If you have vendors off chain, you're going to need a way to pay them, which means you're going to need off chain banking. With intellectual property, if you want to file with the copyright or trademark or patent office for innovation that your DAO has created, then you're going to need to have, you can't say we have 10,000 members and they are all mutual owners, right? You need to have some sort of company wrapper to be able to make a filing to a trademark, copyright, patent office to be able to say, this is the entity that owns this intellectual property and be able to get a registration and the rights that come from registration. Also, if you're trying to enter licenses of the IP that you create, again, there are risks associated with that. And so you want to protect yourself and your personal assets by having a company wrapper that can enter licenses with brand partners or with others who are going to be able to use the things that the DAO creates. Then there's employment law. We have here in the United States, we have federal law and state law. If members are looking like, and we know we've dealt with some of this with like Uber, for example, there are different states that have different perspectives around whether you're a driver for Uber and does that look like employment or does that look like you're an independent contractor? Some of those same questions are going to apply to DAOs with member contributions. When does that start to look like employment versus a member volunteering? And there could also be international law that applies if you have DAO members outside the US. And then again, in regulations, you've got know your customer, you've got anti-money laundering. Governments are very interested in DAOs and NFTs and other Web3 technologies not being used to be able to take illegal funds and be able to make them look clean. And so there is a real concern around not wanting these technologies to be used for things like human trafficking or drug trafficking. And so there's a lot of scrutiny that is now going into at the Department of Justice, at the Securities Exchange Commission, and other governmental agencies around knowing who you're transacting with and making sure that they are not on sanctions lists of prohibited people, prohibited organizations, or even prohibited digital wallets. And then again, of course, there are privacy laws. If your DAO is collecting information, there are some states and some countries where there are going to be privacy regulations around how that data can be used, shared, and when it has to be deleted. How do you delete information on a blockchain, right? The law moves much more slowly than the technology, but that doesn't mean that you aren't still potentially violating law. So if I wrap up, there's this concept in Web3 around WAGMI, and WAGMI is we're all gonna make it, but I believe we make it by design and by having good information. So if I were to recap some of the key strategies around developing projects in legal compliance specific to NFTs and DAOs, so you wanna identify your NFT value proposition. You wanna really be thinking through what is it that you want to offer and why is that going to be valuable to a buyer? Because that will help you understand how to roadmap around your timelines, the features of your NFT, your scarcity. And that will help you think through questions around commercialization contracts and intellectual property and royalties and all kinds of agreements that go in supporting that. You want to think about protecting your creators. Again, do you need to have an LLC or a corporation? Do you need to register for protection of IP? What kinds of laws do you need to comply with as you're getting started and in anticipation of getting started? You want to build and maintain community, and that might look like a DAO. You want to evaluate marketplace terms and conditions where you're making sales, because that's another layer of contracts that are going to impact creators selling and buyers collecting. And then finally, you want to issue your NFT collection, work with your DAO, and keep aware of how the law is evolving, because we are still very early in this technology. And the law at the US on the regulatory and litigation side and internationally is going to be in constant flux. And so again, I invite you to drop your questions in the chat. Thank you for sticking with us. I am, again, JoAnn Holmes. I am an IP and digital assets attorney, and I help innovative organizations to be able to navigate all of this evolving law so that you can build successful products and services. I invite everyone to connect with me on LinkedIn. That's where I'm most active. I'm also on Twitter at HolmesAtLaw, and my website is holmesatlaw.com. So, Iris, we made it. What kinds of questions do we have in the chat?
We did make it. Incredible. Thank you so much, JoAnn. Lots of great content, lots of great information shared. I love how you covered NFTs, IP, all the way through to DAOs, which I know there's a lot of folks thinking about building DAOs, and I think really need help thinking through what are the steps that they can take to protect themselves and protect their members. So there's a lot of questions. Scrolling up to the top. So first we have here, CH is asking, how does decentralization and operating in the private work with law? And I think you touched on this a few times in your presentation, but maybe you can dig into this a little deeper.
Sure. So if we think about a model of Web3 that is truly decentralized, we can use Bitcoin. But even if we think about Bitcoin, Satoshi, whether that was one person or a group of people who came together to create and, for lack of a better term, found the Bitcoin network, they were centralized because someone or some group of people had to drive that concept and get it off its feet as, for lack of a better term, founders. However, Bitcoin is so decentralized. It is, a huge global network now that the United States alone, even if Bitcoin, and this is a very broad way to say it, but even if Bitcoin were made illegal in the United States, if we think about this, effectively, that's what China tried to do last year with Bitcoin by shutting down the miners and creating laws that made Bitcoin very unwelcome in China. Well, then miners just moved to other parts of the world and the Bitcoin network continued because it is decentralized. There's not one place where Bitcoin exists. Whereas let's use Apple by contrast. Apple Corporation exists based in Cupertino. There are different divisions and affiliated corporations for Apple in many different countries around the world. But Apple is based in the United States. And so the United States government has regulatory power over that corporation. So the chicken and egg issue is you can't be decentralized without having a starting point with a core nucleus of founders who build something and drive it forward to the point where there is a global network and it can be decentralized. But you can't get to that point of decentralization where you don't have to comply with any given country's law without having that core network. And so it's really hard to have decentralization without starting somewhere. And wherever you start and those founders who are driving the organization forward, there's going to be law that governs them. I hope that's helpful.
Anyone have a follow-up question in regards to this specific topic before we move on? All right, next question is, in your opinion, what are the notable global jurisdictions with trademark laws that are cutting edge? For example, Europe has GDPR laws around privacy. Curious if there's any cutting edge work being done around trademark and IP law.
So GDPR, the Global Directive of Regulatory Privacy, don't quote me on that. I'm not sure. People say GDPR so often that I'm not usually saying the full name, but it is effectively a privacy regulation that sets standards related to data management for European citizens, no matter whether they are physically in Europe or somewhere else in the world. So it's called a long arm statute because it is not limited to the physical territory of Europe. It reaches out to wherever European citizens are anywhere in the world, which is another way of saying every country in the world needs to comply with the GDPR. Or let me say this otherwise, every organization or company that falls within the regulatory standards of GDPR needs to comply. Countries may or may not choose to comply, but organizations may need to if they want to be able to conduct business in the European Union. So that's a privacy-focused regulation. Intellectual property is a different area of law. Intellectual property includes trademarks and copyrights, patents, domain names, right of publicity, trade secrets. All of those are different types of intellectual property. So if your question is around where is there innovation in trademark law, trademark law, like so many other areas of law, is evolving all the time. Relative to what we're discussing in terms of Web3 and Web3 being global, it may not be innovative, but what I think is particularly useful is there are certain areas of the world where you can get trademark protection across more than one country. So going back to the European Union, there's something called a community trademark where you can get a registration and it covers all of the EU member countries, right? That's very helpful because it's rare that you can get one trademark registration and cover multiple countries. Excuse me, there's also a concept with the African Intellectual Property Organization, I think it is. It has several member countries in Africa where you can get a registration that has recognition across multiple countries. Outside of those two examples, and I manage IP in 140 countries, I'm not aware of any other collaborations where you can get multi-country trademark protection. And it's a real issue when we're talking about the metaverse and NFTs and Daos, where you really have a global community. Copyright protection, for example, you can get a copyright registration in one country, and through something called the Berne Convention, which is a treaty that has been in place for many years, you can get automatic copyright protection in additional countries, but not every country in the world. So different types of intellectual property are going to have different protection across jurisdictions, and it's really important to speak to an attorney to understand Where are you looking to commercialize your IP rights, and where do you have particular IP risks to think about how to prioritize and make investments around that protection?
Nice. Any other questions around this specific topic before we move on? Okay, I see CH had another question here, which is, how do we approach the copyright topic if we're approaching the blockchain from the OG crypto anonymous standpoint, the decentralized peer-to-peer standpoint? Chris, CH, are you here? Could you rephrase that question?
I think while we're waiting, I'll just reiterate that with an NFT, you have two components. You have the token, which is a deed of ownership, and then whatever the token relates to. So let's say that token relates to a PFP, digital art component. You can, through the blockchain and oftentimes on a marketplace, you can sell an NFT without knowing who the other person is, right? You just need the smart contract to recognize you have an asset to sell, they have the funds to buy it, and the smart contract will facilitate the transfer of the funds and the asset across the blockchain. So if we're talking old school peer-to-peer trustless transactions, that's a different issue than copyright, because again, unless there's a commercialization license, all you're buying when you buy an NFT is the right to be able to sell the token or the deed of ownership, be able to sell that forward and be able to privately display whatever the asset is. Let's say it's digital art. You can show that digital art on your phone, you can show that digital art in your home. So you don't necessarily need to know who the buyer is for that transfer to happen. That can be trustless and peer-to-peer on the blockchain.
All right, let's go to next question. Curious about NFT smart contract negotiations and or contracts in practice. In your experience, are they typically established by the creator, or are they also negotiated with clients? Curious if you can share any stories about how these terms are determined, especially as they compare or contrast with other types of agreements. This question is by Amanda. And Amanda, if you want to chime in here, feel free.
I just will. Thanks, JoAnn. You cover a lot of different aspects of how contracts and licensing work, but I guess I'm curious, like with the big players or particular creators, are they coming to the table with potential downstream revenue sharing, and how do those negotiations work when we're dealing with smart contracts as opposed to other things that can't necessarily be managed that way?
So I think it's important, again, to think through the differences between smart contracts and contracts, right? So I mentioned during the presentation, there's this concept of code is law, which is a fallacy. Code is code. Smart contracts are code. And so they are going to be software drafted into an asset which is a token, and that it's going to say things like, this is the royalty that is going to go back to the original creator every time this is resold. And one thing to keep in mind is what can be coded into a smart contract depends on the protocol. So, right, the OG Dapper Labs NFT protocol was ERC 721. We now have 1155, we have 2981. So as the protocols develop, different things can be coded into a smart contract. And again, a smart contract is just code that tells the blockchain what can happen with that token. By contrast, a legacy contract can very much be negotiated. And as long as there's nothing illegal occurring, all kinds of things can be negotiated. So in a traditional license, let's say Disney is licensing the rights to Winnie the Pooh to an apparel maker. They're going to negotiate things like, how long do you have this license? Is it an exclusive license? Are you the only one who can put poo on apparel? Can you only sell that poo apparel in the United States, or can you sell it in multiple countries? If it's a digital asset, it might be a question of, can you only represent poo in Decentraland, but not in the sandbox as a metaverse world? So things around time, territory, scope, revenue streams, those are all aspects, whether you can issue a sub license, whether there's exclusivity, all of those are different aspects of what a traditional license might include, and that can be negotiated, that are different than the sort of binary things that can be included in smart contracts. I hope that helps to answer some of your question.
Yes, thank you so much.
Great.
Awesome. How do you see the prevalence? This is from SW. How do you see the prevalence of derivative lookalike NFT collections being handled in the future? SW, if you want to expand on that question, that's Sheena Williams, feel free.
I was just thinking about how, I guess, they can't be legally copyright. Like, it just seems like there's a lot of collections that look like it's not a Bored Ape, but it's like a Tired Ape, or it's like it's like some other type of, but they're not, it's fairly obvious that they're not supposed to be doing that, but there's no hard, fast regulation or rules. So I'm just curious how that may be handled in the future for folks who do that.
That's a good question. So, the thing I learned first year of law school is that there is no law. There's only interpretation of law. And what I mean by that is we have different companies and people who have different perspectives on whether their rights have been violated, and if they have been violated, what they want to do about that. And then we have courts of law who have different judges, and juries have different perspectives around whether law has been violated. And then we have different regulators and governmental agencies who have different perspectives around law. And then you have different countries with all of those different tiers who have different perspectives around whether law has been violated. So that's why I say there is no law, there's only interpretation of law. So when you say, a collection looks like a derivative, it's a real question. Is it a derivative or not? That's a subjective evaluation that most likely is going to be determined by the owner in the original work making a decision that someone violated their work, and then making a decision, I want to take action against the violator, and then being able to identify who violated. Again, the violator might be anonymous, might be pseudonymous, they might be purposefully hiding their identity and not be able to be identified to be able to take action against them. There are real questions around jurisdiction. If the person or organization that's violating that original work, where are they? Where are they in the world, right? Was there anything where they agreed to US law? Let's say the creator is based here in the US. Did the violator agree to be governed by US law? If not, how are you going to get at them? Maybe they're in a country where US law is not going to be recognized. So there are a lot of different questions that go into this. That is from the legal side. Pragmatically, there is growing pressure on marketplaces to use tools to be able to confirm the identity of a creator, right? And so when you're setting up an account on OpenSea, for example, there are, and I don't want to just identify OpenSea, but other marketplaces, including OpenSea's competitors, where maybe you want to be able to authenticate a digital wallet or use MetaMask, for example, to prove, yes, this is the creator who they're saying they are, so that someone who is a fraudster is not setting up an account on a marketplace pretending to be a creator when they're actually not, and then duping people into buying a collection that's not from the creator that they think they're buying from. So marketplaces have some opportunities to be able to help avoid that deception to buyers and collectors. There's, social media, there's discords, there are ways to be able to out fraudulent collections. So there are some community tools, there are some platform tools, and there are some legal tools that are probably all going to need to be a part of that solution. Is that helpful?
Yes, thank you so much.
Good.
Awesome. Somebody else asked, so Susie Kavanaugh said, building on Sheena's question, could you walk us through version 1 of CryptoPunks and V2 versions? Why was that allowed? And Susie, are you referring to them? Are you referring to CryptoPunks getting bought out? Or could you flesh out the question?
Sure, yeah, thank you. So my basic understanding is that there were these original CryptoPunks, and then there was some sort of bug in the code. And so those CryptoPunks were essentially, quote unquote, scrapped. And then a version 2 of the CryptoPunks appeared, essentially the same, but I think the background color might be different. So you can differentiate between V1 and V2, and they were airdropped. And then some of the V1 holders were like, wait a minute, like, so now you're saying my CryptoPunk is like, I paid money for it. It's no longer a thing because of this code. And apparently some came together and created, I guess, what's called a wrapper, and which essentially fixed the bug that was in the code. And so I read something where somebody was like, Serena Williams owns the exact same CryptoPunk that I do. She just has this version and I have this version. And I was like, wait a minute, like how? And I think there was even, and I don't know what it stands for. I see the acronym on Twitter a lot, DMCA. There was like some sort of, claims to take it down. And somehow the people who were part of the V1 were able to, I don't know how to put it, but basically they didn't have to take it down, and they moved their whole project to, I think it's Rarible. So a different marketplace as well, and they're allowed to have it.
I just posted a link in the chat that I found quickly online.
Oh, perfect.
It's a link to a paper.
Oh, I'll check that out.
An overview for anybody that's listening in, because I had no idea about this, but the abstract is I gave a link to the abstract for anyone who wants to read about it.
And also, JoAnn, I know, I mean, my mind is blown, so much about everything. I also recognize that you may be like, I don't know about this particular thing, but I just thought I'd throw it out there just in case.
Thank you. There are so many things that came to mind as I was listening to you share. And so I'll try to cover a few things that relate. As I was listening to you talk about the V1 and V2 CryptoPunks, I have heard of that. One thing that came to mind was the original DAO, the DAO, that related to Ethereum, and there being a challenge in someone exploiting. And then they did a fork and created what we all now know today as Ethereum. So there's sort of the classic version and the one that everybody uses now. More recently, there was a collection, I think it's called Aku, where they issued a collection and the code had not been sufficiently audited. And there was a problem in the smart contract, and a lot, like millions of dollars in revenue from the issuance of that collection got basically locked in a digital wallet that just is not going to be accessible. So not to speak in detail around any of those things, but to make the larger point that challenges arise in smart contract code. And so one of the key things to think about is having your smart contract audited by devs who are reputable and experienced, so that you can identify the potential challenges associated with a smart contract before you offer a project for sale. Because depending on floor prices and the number of pieces in a collection and so forth, there can be a substantial amount of money at risk. And we have seen circumstances where issues have arisen, even with communities and creators who had the best of intentions and things just went wrong. Another thing you mentioned is the DMCA, which here we're talking about intellectual property, and that's my wheelhouse. So the DMCA stands for the Digital Millennium Copyright Act. And so if we go back to the early 2000s, when Web 2 was sort of, or actually Web 1 was still relatively nascent, but you were starting to have platforms where people could post things. There was a risk of something called contributory infringement. So if we think about Facebook, or even if we go back to MySpace, people were uploading music, people were uploading photographs, people were uploading art, and they didn't necessarily own those assets that they were uploading to their pages and sharing. And so with legacy copyright law, there's a concept of contributory infringement. If you're creating a place for people to host copyright protectable assets, then the concept is, well, you're helping participate in copyright infringement. So what the Digital Millennium Copyright did was it created a safe harbor, or a way to say you can be a platform host. And as long as a copyright owner can put you on notice that someone is violating their copyright, and you review that and take down the infringing material, then suddenly you, digital host, are not a contributory infringer. Same thing with YouTube, for example. People upload things to YouTube all the time, for example, that might include music that they don't own. And because they don't own it, they don't have the right to display it on YouTube. And so again, there's the DMCA safe harbor, where a copyright owner can share proof of their ownership and ask the platform to take it down. Now, in theory, this is great, but in reality, the DMCA sometimes gets weaponized because different platforms may or may not do an actual investigation, may or may not closely scrutinize the evidence that's submitted in support of a DMCA takedown request. Also keep in mind, the DMCA is a US law, so other countries may or may not have similar or different laws around protecting intellectual property owners from third-party infringements on their platforms. So the DMCA can be helpful to copyright owners, but it can also be used as a weapon when someone does not have legitimate rights to try to get something taken down because they know that the platform isn't going to do a proper investigation to really make an assessment about whether an infringement is happening or not.
Thank you for that. Super helpful. I mean, the last part that you just shared with all of us really resonates, because that's something that I'm in Twitter spaces quite a bit, and that's something that artists are talking about. Where they're like, we've put in support calls to whichever marketplace, we provided evidence, and it's kind of like a coin toss as to whether it's going to be addressed or not. And they're like, then what do we do? Do we just kind of have to say, all right, well, we scrap that project and start again? What are our rights? How are we going to be protected?
Well, it's an interesting thing. And one of the things that I pointed out during the presentation is, people say IP, there are different types of IP. So my understanding is that platforms tend to be more willing to take down copyright violations than they are trademark violations. As I mentioned before, I manage trademarks in 140 countries. So I've seen a lot of different types of infringements over my career. I have had success with going to platforms and having infringing trademarks taken down. But as an attorney, one of my strategies is I'm going to throw every type of IP violation I can in that takedown request. So I'm going to request the takedown because this is a violation of trademark. And here are my client's trademark registrations in dozens and dozens of countries. And I'm going to say, and this is a violation of copyright. And if there's a copyright registration, I'm going to point to the registration certificate and registration number as evidence. And frankly, I'm going to sign off as attorney representing them, my client, so that they know I have some authority. And the latent understanding is My client is sophisticated enough in intellectual property and as a business operator that if we need to take additional action, we are aware of what our rights are. So in addressing that piece around, if you've submitted a takedown notice and nothing is happening, then frankly, maybe you go on LinkedIn and find some attorneys for that organization and contact them, or see, is there on the website for the marketplace or wherever it is that the infringement is occurring. Find some additional email addresses on there where you can send in that information and say, I have submitted a takedown request and nothing is happening. I'm going to contact an attorney to discuss additional rights that I might have for enforcing my intellectual property ownership. But before I do that, can you please share this with your law department so that they will get back to me and we can try to resolve it before this results in an escalation, right? Don't make empty threats. That is never wise in my experience, but do know your rights and do have a strategy if it is a significant enough infringement for how you might go about trying to enforce your rights. And it's hard in the context of a brief answer, but do keep in mind, different types of intellectual property are protected in different ways. And so at that point, it is probably wise to have a conversation with an attorney to have a strategy for enforcement. Now, I'm not a litigator. I love to make my clients money. I am unapologetic about that. So I work with organizations, most often, frankly, organizations who are pretty sophisticated, like Umba, Daima, who are thinking through holistic and comprehensive legal strategies and helping them prioritize, because there, as you saw in the presentation, there are so many different areas of law that impact Web3 organizations. Part of what you need to do is prioritize. When does it make sense? When do you need to have a budget for taking action? And when are there other strategies you can take to protect your rights? How is this impacting your revenue stream, right? That gets my attention as an attorney. If a client says to me, this is a risk that impacts our revenue stream, that becomes a much higher priority for me as a legal advisor and a legal architect for that Web3 organization. So that's probably when you are suffering a serious infringement and things like a DMCA takedown are not getting attention, that's probably time that you need to have partnership with an attorney.
Thank you, thank you, thank you.
You're welcome.
All right, next up we have MT is asking, what are the issues with purchasing names, either ENS or RSK domains? MT, do you want to expand on that question?
Yes. So in the ENS community, some of us we tend to purchase celebrity names, company names, whatnot. So I'm just kind of curious, after sitting through this, what would the IP issues be with those names being on say OpenSea, or sitting on them to the owners of the names purchase them or selling them to other people as collectibles, domain name wise?
Yeah, this is not an easy answer. So if we think back to the earlier stages of the internet, we kind of started out with .com, .edu, .org. And over the course of time, additional top-level domains were introduced, country code domain names were introduced. And of course, as you've mentioned, we have ENS, and there will be many other Web3 specific top-level domains. Because there were those in the earlier phases of the internet who were grabbing up company names, brand names, and so forth, here in the United States, we developed something called anti-cyber squatting law. Because effectively, the way that the business community and governments alike saw that was some were effectively trying to exploit and extort companies from their ability to be able to use their brand name as a domain name. Keep in mind what I said earlier in the presentation. A trademark is different from a domain name. So the fact that you own a trademark does not automatically entitle you to a corollary domain name registration. However, the function of trademark law is consumer protection. And so if a consumer is going to be defrauded or is going to be confused by virtue of someone having a domain name registration that leads to a website that confuses a consumer and makes them think, let's say, for example, you have Bank of America, but you have the domain name Bank O America instead of Bank of America. It's a simple typo that someone could make typing too quickly. And what they see when they type in that URL is a web page that looks just like the opening page of Bank of America. But when you type in your new username and password, then the bad guys have got your username and password and can go drain your account, right? We don't want that to happen. That's bad public policy. That is bad for the average consumer. And so when I say this is a complex answer, we have a thing called the Internet Corporation for Assigned Names and Numbers, ICANN. It is the global organization that governs certainly Web 2 or legacy domain name registrations. But when we start to talk about the blockchain, I haven't looked into, frankly, whether ICANN is also going to have dominion over those blockchain addresses. So that is sort of looking at things from a regulatory and legal perspective, right? I pride myself on being a very pragmatic lawyer. And so principle number 1, don't violate law. Principle number 2, protect your personal assets. Principle number 3, how much heat do you want? How much heat can you tolerate? Because when you attract attention of people with deep pockets, it's likely to cost you something. So when you're looking at your budget, does it make sense for you to potentially blow yourself up by an organization that has billions of dollars and legions of lawyers coming at you? And it really becomes a question of, are you doxxed? Are you as hard to find as you think you are? And do you want to deal with the consequences of registering a company name, a brand name, a celebrity name? There are ways that law can be very challenging. Again, I've said a few times, anybody can sue anybody for anything. And how do you deal with that litigation once you've been sued? You've got to prove to a court that you either are right and you don't owe the damages, or you didn't violate whatever law it was asserted against you, or you've got to prove that you never have been sued, you should never have been sued at all. But either way, that usually requires hiring an attorney and spending some money because you've been named in litigation. If you get sued and you do nothing, there's a default judgment against you. And then once there's a default judgment against you, then your assets, we're back to your home, your car, your bank account are at risk. So there's a real question of putting yourself in a posture where you're more likely to be sued, because there are real world risks with that. Now, if you think you're smart enough that you can do these legally risky things and not be discovered, good luck with that. That's not a strategy I would advise my clients to take.
Okay, thank you for that. That's kind of what I was thinking. The answer would be around, especially in terms of whether or not it'd be doxed, and then whether or not there was actually like a follow-up question I had in terms of your opinion on just offering as a service the ability to go in and get those domain names for companies as well.
Now that's much more sophisticated. So the clients who I work with do a myriad of very interesting things, including helping bring along Web 2 to Web 3. Like, we're not there, if we're all honest. We're not fully there at the realization of Web 3 at this point. There are a lot of Web 3 curious organizations who don't have the internal tools or don't know what external vendors can help them along. They don't even know what they should be looking at. Like, that's one of the things I do with my clients as a corollary. I work with organizations and professionals typically who have had success in Web 2 and who are trying to develop strategy and a legal architecture for Web 3. So for you, if you know you see an opportunity where companies should be aware that their brands or their company names, or for celebrities or influencers, that they are not protected in these new blockchain focused domain name extensions that are captured as NFTs, that's a very real and legitimate product and service that you can offer that has, you know, off the cuff without having more detail, immediately appears to have less risk than registering those domain names without being in partnership with the organizations whose brands or names that are related.
All right, thank you for that. Thank you.
You're welcome. Listen, folks, a general theme of mine is I don't want to waste people's time or money, right? And so you can have a very different perspective. As I said at the beginning, none of this is legal or financial advice. We're not speaking under the protections of attorney-client privilege, and there could be nuances of your circumstance that are not appropriate for you to share with me without having the protections of attorney-client privilege. But be pragmatic. If we take law completely out of the picture, one of the fundamental principles of law is reasonableness. So whatever you're thinking through doing, if you were on the other side, or if you were the competitor, how would you feel if someone did the thing you're thinking about doing? That's usually a good indicator that there might be legal risk. And people take legal risks all the time, but if you're going to do that, I would ask you to understand what the implications and costs of that risk could look like. And one of the things that's particularly challenging with Web3 is the law is not developed. And so we are, as attorneys in the Web3 space, we're trying to take legacy law. First of all, there are relatively few lawyers who are even willing to come into this space, because we are trained from day one in law school to be risk adverse and minimize our clients' risks. And there's virtually no way you can be in this space without being more comfortable with risk than the average person. And so if you're thinking through these issues, one of the very first things I say to my clients is be prepared that the law is going to evolve. So we're going to need to develop a relationship on the understanding that we've got to be flexible. I've got to be flexible as your project or your goals and business and product service offerings evolve. And I need to ask you to be flexible as the law evolves, both from a regulatory and a litigation perspective. I'm in this space all day, every day, and it's drinking through a fire hose, honestly. And so I need to be candid with my clients and let them know this has to evolve. It's not like you doing something where the law has been in place for hundreds of years. And so just be mindful about what you're stepping into and being pragmatic around how much risk you're comfortable taking on and what those risks could cost and what the cost of evolving as the law changing could look like. Any other questions, Iris?
It looks like there's one more. The question is on, it's the very last one. What are your thoughts on incorporating a DAO as an LLC in Wyoming?
Good question. So we have a few different options for a legal wrapper. We've got the traditional corporation, we've got LLCs, we've got unis, and I'm trying to think of what uni stands for, but it is another type of legal protection. You've got foundations, for example, based in the Cayman Islands. You've got cooperative organization law. So there are a few different types of organizations or wrappers that you can create for a DAO. That is a jurisdiction or country or state specific question. And that's also a question of what is the function of the DAO? What are you trying to achieve? Are you going to be investing? Are you going to be offering products and services? Are you supporting a protocol? Are you trying to fundraise for a charitable purpose? So depending on the reason that you are creating and operating the DAO, that will give some direction and insight on what kind of DAO wrapper makes sense. My understanding from corporate attorneys who I have heard share their thoughts around the Wyoming DAO is keep in mind we are at the incubator stage in law as well as other Web3 products and services. And so we have this concept here in the United States that states are incubators where we test things. And so Wyoming is testing the Wyoming DAO LLC. It was really created in many ways, and it's still in a version 1. But it was really created for the more legacy or traditional version of a DAO that's more so driven by smart contract than driven by members. And one of the requirements, as I understand it, is that you have a place where you can post so that people can go look at the smart contract and understand what the drivers are around a smart contract driven DAO. Tennessee, I believe, recently passed their own version of a DAO LLC, although instead of it being a decentralized autonomous organization, it is decentralized organization. So it's not so much focused on the LLC being driven by smart contract. It's more evolved, and it recognizes that members actively participate in driving the governance of some DAOs. I know that Vermont and Colorado have also done some innovative things. And then the fallback, just legacy for many organizations, is a Delaware LLC or a Delaware corporation. Outside of the United States, at different points in time, because all of this is changing, the British Virgin Islands, the Cayman Islands, Panama, Portugal, Singapore, and Switzerland have all been attractive for Web3 organizations, including DAOs, for different reasons. So there's not a blanket resolution as to what is the right kind of company wrapper or in what jurisdiction. That should be a conversation with an attorney who is a Web3 corporate focused attorney who can go into detail around what you are trying to achieve. So let's say, for example, you want to invest through the DAO. Well, then if you're here in the States, you might have limitations around accredited investors. Some of those limitations may not exist outside the United States. So those are the kinds of, again, questions that you want to think about when you are deciding what kind of company wrapper is right for protection of your members and where. The other thing I'll say quickly is just because you, let's say, organize your DAO in Singapore or Panama or the British Virgin Islands or the Cayman Islands as a Cayman Foundation, for example, that does not mean that US law won't still impact you, especially if there are US people who are leaders of the DAO or who have treasury authority in the DAO. US law extends, again, long arm, to where its citizens are. And so it's not a simple issue of, oh, I'll just form a Cayman Foundation and so US law won't apply. You also need to look at who is participating in the DAO and what are they doing in that participation. I hope that's a helpful response. Okay, I don't know how long we've been going, but
we've been
going.
Made it
nearly halfway through my water.
I think we can definitely start to wrap up here. So I'm going to open the stage for anyone who wants to unmute and ask a question. You can ask JoAnn a question. You can ask me a question. And if anyone has any updates or announcements they would like to share, you can also unmute and share that.
So this is Cynthia. Quickly, I don't have a question. I just want to let both you, Iris, and JoAnn know how much I appreciate this session. I mean, I am just mind blown now. I'm actually emailing people saying, hey, if you ever need a good IP attorney, check out JoAnn Holmes. So thank you so much. This has really been amazing. Thank you.
I appreciate your kind feedback. I mean, I didn't share this earlier, but I will share now. As I said, I've been an IP attorney for over 20 years. In Web3, I don't have the luxury of just being an IP attorney because sometimes people get to me and they're so glad to get to a lawyer who knows the words they're saying that they're just like asking all kinds of questions, even out to trust and estates type questions. And so what I believe is that Web3 creates an opportunity for more egalitarian IP-based wealth. And that matters to me because I'm a Black woman and I care very much about poverty alleviation in the US and abroad. There are here in our country, in the United States and abroad, millions, billions of people who are unbanked and have not had access to traditional financial institutions. And so that has meant that wealth has been concentrated, but talent is not. And so I really, understanding that there are bad actors, and I as an attorney cannot afford to be Pollyannish or pretend that bad actors aren't out there. My goal is to give good information so people can make informed decisions. And as I said, I most often work with organizations around legal architecture and strategy around the evolving law. But I do things like this for the purpose that there are publicly available resources for people to get good information. So I really appreciate you sharing that. Again, if folks follow me on LinkedIn, that's where I tend to post when I'm speaking, or to share links for podcasts or panels or things where I participate. Later this week, I'm going to be participating in the Atlanta NFT Con. And so I'm really about just helping people have good information so that you can make your own decisions about how you want to participate. And the more that I have the opportunities to do that and be an ambassador for what this technology can do to help people create wealth and be able to use their talents and innovation in the ways that they choose, that is what really makes me happy. So thank you again.
Yeah, my pleasure. Thank you.
Hey, Ms. JoAnn. Hey, Ms. JoAnn, I just wanted to show my support and to say that yeah, this was very informative about the IP law, and yeah, like just the whole overall presentation, very informative. I just wanted to double back again on the ENS topic, the squatting the names. I just had a question. So let's say we enter the space real decentralized, fiat, straight peer-to-peer, or another way where it's we're not involving our bank account or a centralized entity with the space. So how would they technically how let's say we own a corporation or an individual's name, how would that trace to the individual who's squatting the names, and how would they technically be able to sue this person if they don't really know where this is coming from?
So that's a good question. There are organizations, though the first one that comes to mind, but it's not the only one, like Chainalysis, where their whole business model is doing digital forensics. And so everybody has probably heard of examples where some bad actor has done something and then said, you have to pay me a ransom in Bitcoin so that I will stop doing this bad thing. That's not particularly wise, because the blockchain leaves a trail. Now, there are privacy-focused resources, and there are software ways that you can try to hide your identity. But without using some of those more sophisticated tools, effectively, the blockchain leaves a digital trail. And when you have organizations who work with the FBI and the Justice Department and who offer their services to businesses and to wealthy individuals, they go back through that blockchain, wallet to wallet, and see what happened over the course of transactions. And one of the ways that they identify people who think that they are anonymous is a lot of folks' first point of on-ramping to the blockchain is through a centralized exchange, like a Coinbase, a Gemini, a Crypto.com, a Kraken. And so you have to do KYC AML compliance. So just like when you go to your local bank, you have to take your driver's license or passport or something to prove who you are. Same thing when you are setting up an account, especially in the United States at one of these centralized exchanges, they're going to verify who you are so that they can comply with regulation. And so you take crypto and then you move it, say, to your MetaMask or your Ledger. There's a digital history of that. So what these forensic analysis firms will do is they will watch you across the blockchain until they can get back to a centralized exchange where you had to prove who you are. They will issue a subpoena to that centralized exchange and force them to identify. That's one way. I'm not saying that's the only way, but that's one way that people have been identified.
Yes, ma'am. But for example, right? So So like in Atlanta, it's a lot of like coin cloud ATMs where like under a certain amount, you don't have to really you don't have to KYC. So like let's say you buy like a flip, like not a flip phone, but let's say you like buy a track phone with cash or something like that, and you use that SMS to verify on the coin cloud, like how would they like be able to trace that? Like, I don't know, I'm just like, I'm not trying to like, ask too much. I'm just saying like, if you do it real no KYC, like real traditional old crypto way, like I'm just kind of like just trying to figure out like how I understand, like you saying if you use a centralized exchange like Coinbase or something like that, and they can obviously see like who the person is who's getting the crypto and like the bank account that it's coming from. But like if you just take cash and go to like a crypto ATM and you using like a phone that you paid with cash, no trace. I'm just like trying to see like how would they be able to trace that?
So the honest answer is I am not a digital forensics expert, and this is not an area where my practice around legal advice or strategy is focused. I will say there are absolutely people who have been able to get away with things and not been identified. Like if you're sophisticated enough to think through every step of making sure that you don't have a digital footprint, absolutely. There are people who get away with things and don't leave a digital footprint. I think what I would say is you have to be really sure that you're good. Because think about it, wherever there is a financial incentive, somebody is going to try to find a way to exploit a system. But on the other side of that, wherever there is a financial incentive to identify who committed the crime, somebody's going to offer a product or service to identify it. So I think it's a question of, it's no different, right, than if you have a bank heist. If you think you're smart enough that you figured out the security system and you know how long it'll take the police to get there, and you know the way that the police are going to investigate the crime, you might get away with it. Some people are good enough criminals to get away with things and never get caught. The question is, are you good enough to never get caught? So I think your question, I don't ever want to pretend like I know the answer to something. If I don't spend enough of my time and energy looking at those analytics tools to be able to speak to the answer to your question with a bunch of variety. There might be other people on the Zoom who can answer your question in more detail. The example that I gave is one that has been reported, for example, in the news around how people get identified. And the other thing to think about is there are different perspectives on this. It can be controversial. If we think about what happened with Terra Luna just a couple weeks ago, and UST, there are some people who think that that was an attack on an exploit, and someone made, I've heard different estimates of $900 million to $1 billion, bringing down a $50 billion network, right? Some people are like, well, that's how capitalism works. If you found the exploit, then you got rewarded for finding the exploit. Other people are like, folks got wrecked and took their lives as a result of somebody capitalizing on that exploit. So there's a lot to be said around what tactic people want to take. But if you think about it from a basic capitalistic marketplace, expect that people are going to find vulnerabilities and act on them if there's a profit or some other incentive, and expect that there's somebody on the other side of that who sees an opportunity to be paid for finding whoever took advantage of that exploit.
Okay, I really appreciate you. Thank you so much.
I appreciate you too. Thank you for your question.
So this is Susie again. First and foremost, just piggybacking off of other people, just so appreciative of you. Thank you. It's crazy how I came across this tweet. It's not crazy because I follow Iris but just happy that I found you, jumped into this session. you know, I was expecting you to be very knowledgeable on, you know, why IP and digital assets. And then when you started pulling out the DAO stuff and everything else, I was like, all right, she's not messing around. So, but I'm curious, you know, there's so many layers. I feel like this is such a vast ecosystem, and people might have their hands in a little bit of everything, or they might just kind of be in one, let's just say one vertical. In your opinion, based off of the work that you're doing and the clients that you have, is there something that people aren't talking about enough that we should be focusing on or thinking about or anything like that?
First of all, Susie, you have been so kind here tonight as well as online, and I want to personally thank you. You know, you're a person, I'm a person. Kindness is not lost on me, and I want you to know I appreciate the kindness that you've shown me. When Iris and I were planning for this session, I told her the 3 key issues that I, as an attorney, am most concerned about in Web3. And that I am most consistently looking for feedback from other attorneys in Web3 around. And I covered those issues in the presentation. And so the key things I'm concerned about are NFT commercialization rights. And I don't think there's enough understanding from creators around what the IP and contract issues are. And there's not enough understanding from buyers around what they're buying when they buy an NFT. So that's the first issue. The second issue is around securities and the fact that the Securities and Exchange Commission, possibly purposefully, is continuing to rely on a regulatory standard issued in 1930, that being the Howey test, that is opaque and very difficult to apply with confidence, which means that people need to take risks to be able to offer products and services. Now, from the SEC's perspective, I imagine that they would say, we don't want to give clear, bright line rules, because if we do that, people will come right up to the rule and somebody could get hurt because we missed something. I frankly think that's a little bit of a cop-out. We need law. Like, we need to know what is illegal and what is legal. Who wants to be in this gray space where they're inadvertently taking risks that they didn't want to take? So, I also push back around the SEC sort of regulating through enforcement. One of the things that they did last year is tell Coinbase, if you issue a yield product, then we're going to sue you. And Coinbase came back and said, well, tell me what we need to do to be in compliance, but they wouldn't. There are examples of organizations that I have heard securities attorneys mention, of organizations going to the SEC and saying, tell me how I do this the right way, so I don't get in trouble and I don't run afoul of the law. And the SEC won't give them clear guidance. I don't think that's right. I don't think that's how any lawmaker serves our American community fairly or reasonably. So I have an issue with that. I also have an issue with the hypocrisy of regulation that says you cannot invest in certain digital assets, but you can go to the casino and mortgage everything you have down to the last penny. That doesn't make sense to me. Be consistent. So the securities issue is a big thing. Again, I'm not a securities attorney, but I pay a lot of attention to securities because I'm developing legal architecture for my clients. And if we get to the point where we need a securities attorney's depth of expertise and experience, then we call them in. So that the securities, the NFT IP commercialization is one, securities two, and the third one is Daos. I think that people generally don't have enough visibility to the myriad of different areas of law that impact Daos. I think tax collectors are coming at every level because there's too much money involved. And as DAOs become even more popular and they offer more and more products and services that generate revenue, it is not pragmatic to expect that tax collectors and state and federal treasuries are going to say, we're good, we don't want any of that money. That's not how we operate. That's just not a reality. So I think that the tax, if you talk to any attorney in Web3, they're going to raise the tax issues. There are tax issues around NFTs. There are tax issues around buying and selling cryptocurrencies. There are tax issues around DeFi. So there are a lot of tax implications. And just like there are not enough Web3 attorneys who have a depth of experience in this ecosystem and can see the sophistication of the questions that builders and innovators and creators are grappling with, there are also not enough crypto CPAs or digital asset CPAs who really understand the depth of these issues. So we're still early. We need a lot more professionals. And one of the things I do, especially when I'm speaking to women and especially when I'm speaking to people of color, is help them understand, if you are in marketing, if you are in finance, if you are in law, you can be a leader in your corporation by knowing this space and teaching your corporation how they can have a Web3 offering that makes sense to Web3 communities. You can take your legacy skill set and help any number of different customers and buyers be able to apply marketing in Web3, apply finance, apply legal. We need the whole gamut of professional advisors in this space because Web3 is going to continue to evolve. And the people who just get mired in the FUD, okay, so be it. Like I have no authority to judge them, but to me, that's akin to being in the early 2000s and saying, what's this internet thing all about? Why do I need it? What are we going to use it for? I think it's a fad. I saw that when I was a baby attorney, and 22 years into practicing law, it's very clear to me that Web3 is going to have so many use cases. And I frankly am not satisfied with the same people who earned all the wealth in Web 2, absorbing all the wealth in Web 3. If I have anything to say about it, that's not going to happen.
So I think you're amazing. I'm officially in love with you. I'm claiming my love in front of everybody. I just love the passion with which you speak. I mean, I would be standing, I feel like I should be standing up and like just applauding you. So thank you for being you. Thank you for being so present. Thank you for, this opportunity to just spend time with you and everybody else in the community and to learn. So thank you, thank you, thank you.
You are sincerely welcome. And I thank Iris for giving me the opportunity to be able to speak to you all.
Awesome. We've got 4 minutes left. Anybody else want to make a comment, ask a question, or make an announcement before we wrap up?
Yes, Iris, this is Anthony Mathis. How you doing?
Hey, Anthony.
Quick question. So, JoAnn, where will you be this week at this NFT ACL event?
So
Which
on
days and
Wednesday,
what time?
yeah, thank you for asking. On Wednesday at 11 a.m., I am speaking on a panel around intellectual property and Web3. And then at 2:30, I think it's either 2 or 2:30, I'm moderating a panel on name, image, and likeness in the metaverse.
And is that name, image, and likeness similar to what's going on with the NCAA?
It could be. I think it's going to be a really fun panel. My job is to moderate that, not to necessarily interject too much of my thoughts, but on a personal basis, I'm a huge fan of giving athletes at every right the opportunity to be able to exploit their name, likeness, and image. These athletes are going out, giving it their all, while also in college trying to earn an education. There's no guarantee that they're not going to suffer an injury or have some other kind of catastrophic event that preempts them from being able to exploit their talent as a professional. Meanwhile, colleges are making billions off of athletes. So I was really happy to see the litigation that resulted in athletes having more rights to exploit their name, likeness, and image. I think it's going to be, and it kind of depends on what the panelists and the audience want to speak to, but I think about it in terms of athletes, social media influencers, celebrities. There are really interesting questions around in a metaverse, like what metaverse worlds do you want to present in? How do you want to license your rights in those worlds? How do you have a strategy, right? I think if you have built up a name and a celebrity, it's important not to dilute it. And so having a strategy around where is your audience, not unlike NFTs, where is your audience in your community? What value are you offering? You know, one of the things that I love about Micah Johnson and the, I think I'm saying it right, ACRU project, is that he's really thinking about ecosystems. And so he's thinking
Are you talking about the baseball player from Los Angeles Dodgers?
Exactly,
Okay.
exactly. Really smart guy.
Yes.
And he's thinking about like a whole ecosystem around characters. And so maybe you use your character to play in a game, and then you see your character in a film, and then you see that character participating in a community in the metaverse. And then if you are an NFT owner of that character, it could also be authentication to IRL events. And so really thinking about the ecosystem value, instead of segmenting NFTs from the metaverse, from traditional media, how do you create a value system as an IP creator? That's the kind of strategy conversation I like to have, because as I said, I manage global intellectual property assets, and I'm a Web3 lawyer. And so I'm thinking about interoperability and value to communities, and thinking about how you maintain the attention of that community over the course of time. And I think the communities that really stay with the creator are symbiotic, where the creator is thinking about value to the community, and the community is thinking about what new innovative things do we have to offer back to the project, so that everybody wants to keep involved themselves and they want to invite others. They have a compelling story to tell. I don't think Web3 can be slightly better than Web2. It has to be step change better. And I think the collaboration of minds is the way that you figure out that step change.
Okay. So this Wednesday, 11 a.m. and 2 p.m.
11 a.m. in either 2 or 2:30. There is a website where you can see the agenda.
Okay. Thank you.
You're welcome. I hope I get to see you. If you come up to me and say hi.
Oh, I definitely will.
Thank you.
Definitely. Thank you.
All right. I think that's it for today. Thank you so much, JoAnn. Again, if you haven't taken down JoAnn's info, it's on the screen. Make sure you grab a screenshot, send her email, hire her, you know, bring her on for your services, recommend her to all your friends and family. And we are going to put this video up on YouTube, so there will be a full recap that you can revisit or share with friends and family. We have our NFT social this Friday in Atlanta at ASW Distillery, which is the location we had at the last, for the last social. So if anyone wants to go and network, that's on Friday at 7 p.m. We're also adding a segment to the social event where people can make announcements. So if you have a project that you're working on, if you have art you're going to drop, if you're looking for a co-founder or a team member or anything of that sort, you can, when you go to register, you can submit a form to request to make an announcement. And we're looking for about 6 or 7 people to make announcements. And I believe that's all my updates. Thank you so much for joining us, and we will see you on Friday.
Bye, everybody. Go build great things.
Thank you so much. Thank you.
You're welcome,
everybody.